Do you qualify under New York City new sexual assault lawsuit law? A practical guide. Attorney Andrew Stengel. The question we hear most from survivors is a simple one. Does this apply to me? The answer is often yes, even for people who assumed their legal options were gone. Here's a practical breakdown of who qualifies under New York City's new victims of gender motivated violence law provision, New York City Administrative Code, Section 10 1104.1. The basic eligibility requirements. To have a claim under this law, you generally need to meet four criteria. The abuse occurred in New York City. The VGMVL applies only to incidents that took place within the five boroughs: Manhattan, Brooklyn, Queens, the Bronx, or Staten Island. If the abuse happened in New York State but outside city limits, you may still have claims under other laws, but not this one specifically. The sexual assault or sexual abuse occurred before January 9th, 2022. This law specifically addresses a gap that left survivors of pre-2022 abuse without rights. If your abuse occurred after January 9th, 2022, you may still have claims under the standard GMVA provisions. Speak with an attorney. You suffered harm. This includes physical injury, psychological trauma, emotional distress, and economic harm. Survivors don't need to have visible physical injuries to qualify. The abuse was a crime of gender-motivated violence. New York courts have consistently held that sexual assault and non-consensual sexual contact are inherently acts motivated by the victim's gender. You don't need to prove the abuser hated women. The nature of the act itself satisfies this element in most sexual abuse cases. You don't need any of these things. One of the most important things survivors need to hear: the law does not require a prior police report or criminal complaint, a criminal arrest, charge, or conviction of your abuser, prior civil litigation, medical records from the time of the abuse, witnesses. You can come forward today, decades after the abuse, with nothing but your account of what happened and have a viable case. Who can be sued? The law reaches anyone who commits, directs, enables, participates in, or conspires in the commission of gender-motivated violence. In practice, this means the person who directly committed the assault or abuse, an individual abuser, companies or organizations that knew or should have known about abuse by an employee, institutions that failed to protect students from known abusers, schools and universities, medical institutions that enabled abusive providers, hospitals and medical practices, the City of New York for abuse at detention facilities, foster care agencies, institutions that covered up or transferred abusive clergy or staff, religious organizations, teams, leagues, or clubs that failed to act on known predators. What if your case was previously dismissed? If you filed a lawsuit between March 1st, 2023 and March 1st, 2025, that was dismissed because of the retroactivity ruling, you may now be able to refile under this new provision. This is a significant opportunity for survivors whose cases were thrown out through no fault of their own. The deadline, July 29th, 2027. This 18-month window is fixed. Once it closes, the law will not reopen it again. If you believe you may have a claim, please don't wait until close to the deadline to consult with an attorney. Cases take time to build, particularly against institutions, and early action gives your legal team the best chance of success. Even if you are not sure whether you qualify, a free confidential consultation costs you nothing. The answer could change your life. Schedule a consultation with us by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.